want to talk about DACA recipients with order of removal in absentia. Basically, they were order removed in absentia and later on travel outside of the United States on parole, and now they seek to adjust status based on marriage. Some of them got their green card denied. USCIS denied their green card applications because USCIS lacks jurisdiction over that green card application. I want to talk about it because there's a lot of confusion on whether to go with USCIS or whether to start to reopen the case first. My name is Bijoux Ngwanda, as you know it. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we deal with complex US immigration law cases. If you are new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, don't forget to comment below. Also follow me on all platforms. Links are in the description box below. If you need a consultation with me, please schedule it on your own time. Consultation link is in the description box below. By the way, USCIS, as you know it, they're raising the fees, filing fees, starting April 1st, 2024, next month. This is my last call. If you want to do it with me, really, at least by tomorrow, we should start the filing process. Otherwise, it's going to be late because I cannot be rushed in the process, okay? And not to mention for people who are adjusting under humanitarian-based type of visa, for example, VAWA applicants, if they're filing concurrently their green card application with the VAWA application of USCIS, it's better to wait because after April 1st, the fees will be automatically waived. So they don't have to pay for the green card and they don't have to request a fee waiver, in order to waive the fees. So that's a good news, at least for certain individuals, right? So let's get into the topic. This topic is really crucial, okay? First of all, the first thing to know first is that if a person is order removed in absentia, it simply means that the person was not there, failure to appear in court, and they order you removed. Well, if you don't show good cause, you have a 5-year ban, period. And if a person who was actually ordered removed in absentia, then later on travels outside of the United States on advance parole, like the case of the DACA recipient, well, that person triggers another 10 years, okay? Because now they travel, they were unlawfully present, then they go outside, then they travel outside, depending on whether they accrue unlawful presence, right? Because sometimes they get married, after 21, and depending on whether they accrue unlawful presence prior or not, because when you're a minor, you don't accrue, and then the unlawful presence stops when you receive DACA. So depending on whether there's some type of lapse in that, in between, if there's a lapse of DACA approval notice or something around those lines, then yes, that person will trigger another 10 years bar. So in total, 15 years bar. But depending on which one started first, but anyway, you trigger 2 bars, right? So then the person comes back and try to adjust status based on marriage. Usually those people will go directly to USCIS because they don't know better. While USCIS eventually will deny the case because of lack of jurisdiction. What exactly can you do? Well, 2 ways to go about it. Some people will file the form 212, please adjustment of status with USCIS in order to seek permission because they traveled outside. Now they want to seek permission to apply for the green card. That process is it takes too long and it might get a denial as well. You just don't know. In my opinion, the best way to go about it is to file a motion to reopen. But guess what? If you try to join ICE, most of the time, at least 80% of the time, ICE will deny to join the motion because they will say that because you travel outside of the United States, then it's a post-departure bar because you have executed your order of deportation because you actually left the country. And when you come back, they don't have jurisdiction either because of post departure bar. But we know that a lot of circuits, they struck down that post departure bar, but ICE sometimes they just go with what they want. Okay. What are you gonna do? Well, you need a qualifying attorney to try to help you out, because now what we're gonna do, we're gonna file a motion, a statutory motion directly with the court, and show good cause and exceptional circumstances, because now you have DACA, good cause, because basically when they order you remove, obviously you were a minor, you didn't have control over your own person, there's no way you could have shown up to court, right? That's good cause. Or we can try to reopen based on defective notice to appear. If the notice in question is defective, we can try to reopen based on that. That one we can join ICE at least to try to reopen the case based on defective notice to appear and dismiss the case. That way USCIS regain jurisdiction, then we go back to USCIS to adjust status. So if ICE has denied your motion, your joint motion to reopen the case, it's not the end of the hold. You can always contact us, because now we're gonna file a statutory motion with the immigration court, show good cause, exceptional circumstances, and most likely judges are understanding the process, and then they will most likely grant it. Okay. If you need a consultation with me, because this is a difficult subject, please schedule it by using the consultation link in the description box below. Until next time, bye bye.